one of our colleagues at Boxar, Evarn. He's a principal program evaluator at Boxar, and he's going to be speaking about the impact of private versus public legal representation on criminal proceedings. I think we can have the doors closed now. Thanks. Thanks, Evarn.
Am I on? Yeah, fantastic. Well, good afternoon, everybody. As Paul mentioned, my name is Evarn. I'm one of the researchers here at Boxar. I'm here to talk about some preliminary results for a work in progress together with Suzanne and Don, and also very much legal aid. Without their help, this study wouldn't have been possible. Before I get into the details of the study, I'd like to first lay the institutional background around where this study takes place in. So one of the substantial, policy challenges in New South Wales justice the past few years has been this issue of the persistent rise in court delay. And this has attracted a lot of attention, not simply because a rise in court delay is very expensive, but because it can have negative effects on defendants and victims who have to endure longer trials, but it can also have negative flow-on effects to other parts of the justice system. Importantly, when a case is finalised, when it's appropriately finalised earlier in criminal proceedings, there are also substantial savings. And this is especially the case for indictable offences, and I'll describe what indictable offences are in New South Wales in a second. I have an example here. So if we have a case that's finalised in the New South Wales District Court, which costs roughly 10 times greater than a local court. So the difference is substantial. I mentioned indictable offences. In New South Wales, there are two types of indictable offences, broadly speaking. We have Table 1 and Table 2 offences. And the interesting aspect about these offences from the perspective of our study is that Table 1 and Table 2 offences, they can be finalised either in the local court or brought up to the district court. The second type of indictable offence that we have in New South Wales are called strictly indictable offences, and these are the most serious of cases that we have, series of offences, sorry. And these have to be dealt with in the higher court. So when I say higher court, what I mean is the district or Supreme Court. So I mentioned court delay. So here's what I mean. On the left, I have the average court delay for Table 1 offences, for Table 1 offences that were finalised in the local court. And on the right, we have Table 2 offences that were finalised in the local court, the average court delay. A couple of interesting things to note about these graphs. You can see that, oops, I keep pressing the wrong button. You can see that the bars are rising between 2015 to 2017. So this indicates that court delay is increasing. Another interesting aspect to note about these graphs is that cases that were finalised following a guilty plea are finalised much quicker. The court delay is much smaller than for cases that went to a defended hearing. You can see that there's a substantial difference there in the bars. This is a similar graph, except I have the Table 1 and Table 2 offences that were finalised in the district court. Again, note that there is a rise over time in court delay, so the bars are getting bigger, but we also have the same feature where cases that were finalised following a guilty plea, we have a shorter court delay than for Table 1 and Table 2 offences that went to trial, which is the red. One more thing I'd like to point out about these two graphs is that for Table 1 and Table 2 offences, you'll note that the court delay is much higher for cases that, for Table 1 and Table 2 offences that went to the district court. You can see here the axis represents the average number of days before finalisation, which is much higher for the district court than for the local court, roughly double in terms of the maximum number. So in other words, when a Table 1 and Table 2 offence is kept down in the local court, the court delay is much lower. Okay, so the last bar graph I have are for the strictly indictable offences. Again, you can see the rise over time as well. We also have the same feature where cases that were finalized following a guilty plea are also finalized quicker than cases that went to trial. Okay, so that is roughly the institutional background that we have for this study. What we try to, I guess what we try to investigate is the impact that different defense lawyer types can have in contributing to court delay in New South Wales. So specifically, what we do is we take legally aided private lawyers and we contrast them with public lawyers, or what legal aid call in-house lawyers. And we compare these two types of lawyers and see how criminal proceedings outcomes differ between these two types. The important thing to note here is that we don't include privately retained lawyers, so we're only specifically focusing on legally aided private lawyers. So that's roughly what we try to accomplish in our study. Here's how the rest of the presentation will flow. So next I'll talk about legal aid and how they assign cases between their in-house lawyers and legally aided private lawyers. Then I'll briefly discuss the methods, in other words, how we generate the results. I'll present the results separated by offense type, so Table 1 and Table 2 offences and strictly indictable offences. I'll very briefly discuss a robustness check that we ran of the main results, and then I'll end with some concluding remarks. Alrighty, so in New South Wales, if you're charged with a criminal offence, you can seek legal aid by submitting an application to Legal Aid New South Wales. Now, these applications are means tested. Amongst applications that are approved, the criminal law practice manager at each legal aid office is responsible for assigning them between a private and an in-house lawyer. Now, the full policy is actually available online, but essentially the important aspects of this are that by default, legal aid prefer to keep cases in-house. So they try to retain as many cases as possible to their own lawyers, which is our understanding. Whenever that's not possible, so typically, for example, whenever an in-house lawyer is unavailable to act due to, say, excess workload, cases are then assigned out to private lawyers. There are a range of factors that legal aid consider when deciding to assign a case to a private lawyer. I've listed some here. For example, if a client has a particular disability and there is a private lawyer that has a history of helping clients with that particular disability. Another factor that legal aid considers is convenience for the client. So if the client lives in a rural area where there is no legal aid office and it's more convenient for them to deal with a private lawyer, then that's considered. Then there's also conflicts of interest that can occur between legal aid and, say, the case. These are just some of the characteristics that are considered. Like I said, the full policy is available online. Another important thing to note for our study is that legal aid then also pays these private lawyers, and they pay them according to a fee schedule that is also set by legal aid. So we'll see why that's important in a minute. So this is a rough description of how legal aid go about assigning cases. Okay, so the statistical methods. Legal aid provided us every single approved criminal law grant of aid between January 2012 and December 2016 for indictable offences only, so we're only focusing on indictable offences. We then took this data and linked it to Boxar's reoffending database. And if you're a statistician, you know that's Boxar's ROD is great because that gave us a whole bunch of information about criminal proceedings outcomes. It gave us a lot of information about the cases, so case characteristics, defendant characteristics, which are very useful in this study. One thing I would like to mention is that we don't include Indigenous defendants in our sample, so we excluded them from the analysis. And the reason why is because we weren't able to determine which Indigenous defendants were represented by legal aid or the Aboriginal Legal Service. And so that's why we made that decision. Okay, so in this table, I've got a breakdown of our sample. Actually, I'll use here. So for Table 1 and Table 2 offences, we have roughly 7,700 cases. In column 2, this tells us the proportion that were assigned to private lawyers during our study period. So you can see for Table 1 and Table 2 offences, we have roughly 40% that were assigned to private lawyers. For strictly indictable offences, we just have slightly over 8,100 grants, and approximately 50% were assigned to private lawyers during that time. So we've got a pretty nice distribution, 50-50 distribution in our study. All right. So the research question that we're trying to answer is, what is the impact of private versus in-house lawyers on criminal proceedings outcomes? The last phrase is important, right, among otherwise comparable cases. So what we're trying to do is estimate, or to isolate the influence of different lawyer types on our outcomes, holding constant other related factors. And in words, that's essentially what this equation tries to achieve. So YIJT is the criminal proceedings outcome for case I assigned by Legal Aid Office J in month and year T. What we're interested here in this equation is this variable here, which will tell us the average difference in the outcome for cases assigned to private lawyers compared to an in-house lawyer. We did say that we want to compare comparable cases, so that means that we have to control for all the other differences in cases between that are assigned to private and in-house lawyers, and that's what we try to achieve in the rest of the equation. So case-related characteristics are included here, and I'll outline those in a minute. We also include a bunch of fixed effects, legal aid office, court, and time fixed effects as well, and the epsilon is what we don't observe. So I've been talking a lot about criminal proceedings outcomes. What are they? We split them up by the offence types. So for Table 1 and Table 2 offences, the outcomes that we study, we look at the probability a case will be dealt with summarily, or in other words, will be dealt with in the local court. This is important because remember that when we were looking at the case, the court delay, we found that the court delay is smaller for Table 1 and Table 2 offences that were finalised in the local court. Another outcome that we study is the probability a case will be dealt with summarily after a guilty plea. Again, remember that we saw when cases were finalised following a guilty plea, the court delay was much lower. The third outcome we look at is amongst cases committed for trial, the probability a defendant will enter a guilty plea. Or this is what we're calling a late guilty plea. Now, the reason why this is important is because there's a lot of effort that goes into preparing a trial. And if a defendant then enters a late guilty plea, or a guilty plea after cases have been committed for trial, all of those resources have gone to effectively been wasted. So we also looked at that. For strictly indictable offences, we have two outcomes. The probability that a defendant will be committed for sentence. Again, remember we saw that cases that went, strictly indictable offences that went to trial, the court delay was much higher, larger. We also looked at the probability a defendant will enter a late guilty plea. So these are our outcomes. Okay. So the results. Here we have a simple mean comparison for the probability a case will be dealt with summarily. I say a simple mean comparison because we haven't yet included those controls. I just want to see if there are differences to begin with, and then see how that difference changes as we add controls. So on the y-axis, on the vertical axis, we've got the probability that a case will be dealt with summarily or dealt with in the local court. The blue bar represents the probability that a case assigned to a private lawyer will be dealt with summarily. So that's 63%. The red bar is for in-house lawyers, and that's 77%. So the difference there is that, well, this is telling us that cases assigned to a private lawyer are 14 percentage points less likely to be dealt with summarily compared to an in-house lawyer, and that is highly statistically significant. So that's quite a big difference. If we look at the probability a case will be dealt with summarily after a guilty plea, again, we do find quite a large difference, 13 percentage points, between private and in-house lawyers, and that, again, is highly statistically significant. If we look at the simple mean comparison for the probability that a defendant will enter a late guilty plea, we find that defendants represented by private lawyers are 9 percentage points more likely to enter a late guilty plea. That difference, again, is highly statistically significant. So these are our sort of initial results, trying to see what the data is telling us at the surface level. The more interesting question is what happens when we include our control variables, when we try to take out those differences from the cases assigned to private and in-house lawyers. So this table here include the regression coefficients for cases dealt with summarily. Now, as we move from columns 1 to 6, I'm adding more controls to the variable, to the model. And these are the full set of controls that we've listed here. We include defendant demographics, the location of the defendant, prior offending history, their bail status at finalization, the number of extensions for a case, the principal offense committed, and as well as those fixed effects that I mentioned. So I'm adding more controls progressively as I move from columns 1 to 6. What we're interested in here is these numbers here, which tell us the average difference between private and in-house lawyers. And you can see that as we move from left to right, the estimates don't really change. The results are telling us that cases assigned to a private lawyer are between 11 to 12 percentage points less likely to be dealt with summarily, or in other words, to be dealt with in the local court. And all these estimates are highly statistically significant. Oh, sorry. Okay, so here we've got, in panel B, we have dealt with summarily after a guilty plea. Again, as we move from columns 1 to 6, I'm adding more controls. Again, we also find that these estimates don't really change as we move from left to right. They're telling us that cases assigned to a private lawyer are between 13 and 14 percentage points less likely to be dealt with summarily after a guilty plea. And again, these are all highly statistically significant. The final outcome that we looked at for Table 1 and Table 2 offences, the probability of a late guilty plea. The results are telling us that defendants represented by a private lawyer are between 8 to 9 percentage points more likely to enter a late guilty plea, and these are highly statistically significant as well. So in summary, compared to in-house lawyers, we find that criminal law cases represented by a legally aided private lawyer are less likely to be dealt with summarily, less likely to be dealt with summarily after a guilty plea, and defendants represented by private lawyers are more likely to enter a late guilty plea. So those are our results for the table offences. What do we find for the strictly indictables? So again, I start with a simple mean comparison. This is for the probability that a case will be committed for sentence. We find that cases assigned to a private lawyer are approximately 16 percentage points less likely to be committed for sentence compared to an in-house lawyer. That's highly statistically significant. If we look at the probability of a late guilty plea, defendants represented by a private lawyer are 5 percentage points more likely to enter a late guilty plea. And again, that's highly statistically significant. I've been saying that a lot. Okay, so those were the simple mean comparisons. What happens when we include controls? Not much. I mean, for the probability that a case is committed for sentence, as I said, moving from left to right, from columns 1 to 6, I'm adding more controls, and it's the same controls as the previous table. The results are telling us that cases assigned to a private lawyer are between 14 and 17 percentage points less likely to be committed for sentence. Highly statistically significant. For late guilty plea, we find that 4 to 6 percentage points more likely for private defendants represented by a private lawyer, 5 percentage points more likely to enter a late guilty plea. Once again, these are highly statistically significant. So in summary, for the strictly indictable offences, we find that compared to in-house lawyers, criminal law cases assigned to a legally aided private lawyer are less likely to be committed for sentence, and they are more likely to enter a late guilty plea. Or the defendants they represent are more likely to enter a late guilty plea. Okay, so we also conducted a robustness check of the main results. Now, we learned that a case, at any point until finalization, a case can be transferred between lawyers. Now, so for example, a case may initially be assigned to a private or an in-house lawyer and then transferred at some point. This is problematic because if a case was transferred, it's entirely reasonable that a different lawyer was assigned at the time that the outcome was determined. So for example, if a case was committed to trial, it could be that an in-house lawyer was in charge at the time, committed for trial, and then transferred to a private lawyer. So then we would be incorrectly attributing that difference to the legally aided private lawyer. So to deal with this, we excluded the cases that were transferred. So I've got here, for Table 1 and Table 2 offences, roughly 15% of cases were transferred during the study period, and for strictly indictables, that was 16%. So we excluded these cases from the study, from the data, and reran the results to see if they changed. And doing that, we did not find much difference. The results don't change meaningfully, so the conclusions remain the same. Okay, so what could potentially explain the pattern of results that we've observed in the data? The first is the difference in financial incentives between an in-house and a legally aided private lawyer. This is something that's been noted by other organisations previously. So I have here, for example, the New South Wales Law Reform Commission. And in 2014, they noted that private lawyers do have an incentive to, for example, to submit late guilty pleas. And I guess just to explain, so very generally, an in-house lawyer is paid an annual salary, whereas, and this is again a brief summary, the fee schedule for a private lawyer increases the more time that is spent on a case. So as the Law Reform Commission noted, there are no financial incentives for conducting, for example, pre-trial negotiations or for trying to, I guess, finalise cases earlier in proceedings. So that is a potential reason. There are also other reasons that could explain the pattern that we observed. It's entirely possible that in-house lawyers are able to build more effective relationships with public prosecution. This is important because that means the consequence of that is they're able to discuss, the prosecution and the defence are able to conduct more transparent negotiations earlier in proceedings. And that could explain what we're seeing. And this has been noted in other contexts, for example, in the US and Canada as well. Another potential reason, private lawyers who are attracted to legal aid work, I'm trying to phrase this diplomatically, may be less skilled and or experienced than other lawyers. So what I mean by this is, for a private lawyer to be eligible to represent a legally aided client, they have to nominate themselves. And so it's possible that those private lawyers who are choosing to nominate themselves are different, are not typical of the private lawyers in New South Wales in general. The last reason, of course, is that a defence lawyer may extend criminal proceedings to obtain better outcomes for their defendant. That's also entirely possible as well. And we're not able to discount any of these possibilities in our study. So lastly, I just want to quickly acknowledge the contribution of legal aid because they did give us their data and this study would not have been possible without them. So thank you very much if anyone here is from legal aid. And I also want to acknowledge Maya and Mark, two colleagues of mine who helped me put the data together, which was a nightmare. Okay, thank you very much. Thanks.
Well done, very clear. Thanks, Evarn. Questions from the audience? Please, down here, could we get a microphone in the front? Thank you. If you could just say your name and where you're from before your question. Thanks.
My name's Julia. I'm from the Department of Justice. My question is, does your data set include federal offenders?
This was state. So we only looked at state offences, yeah. So we didn't.
Thank you.
Yeah.
Thanks. In the middle.
Hi, my name's Hamish. I also work at Boxer.
Hey.
Hey. I was just wondering, with the data set, so I know you made one of the points could be that the private lawyers are holding out to get better outcomes for their client. Do you have, so for cases that go to a defended hearing, or something, do you have some way to try and have a look at differences in outcomes, whether it be like proportion of guilty verdict or sentence length or some other form of penalty or something like that?
Yep, so before I answer, I didn't put Hamish up to that, even though I sit right next to him at work. But thanks, Hamish. So that's something that we've considered because, as I noted, it's entirely possible that although there is this difference we find in criminal proceedings, in the finalisation of cases, it's possible that private lawyers are better obtaining better outcomes for their defendants. It's not easy to study. We can look at it. We do have the data for it. But it's not easy because there are many things that go into a sentencing decision. For example, it's more than just the type of lawyer that determines whether or not someone gets a prison sentence and the length of that prison sentence. And to be able to observe and control for all of those things is not simple. But it's something that, would be very interesting.
Time for a couple more questions. There's one in the middle, thanks.
My name's Marita from Urbis. I was just wondering what Legal Aid's thoughts were on this data, or on this finding.
I think they were very diplomatic about it. I don't know, I'm not really involved in too much of that. I know they were happy. But, I guess I don't... To be fair to Legal Aid, the first thing they noted was that private lawyers are important. And, they do a lot of good work for Legal Aid. I couldn't comment. I don't have specifics, I'm sorry.
Yeah, that's fine. It's just interesting because in other states that ratio is different. Like in Queensland, it's about 80%, I think, is private lawyer, legally aided work. So it's just that's I guess a policy decision as to how much they do in-house versus outsource. So
Right.
Anyway, thanks.
Okay, I think we can fit one more in if someone has a burning question. No? Okay, everyone, thank you to Evarn.
Thanks, Paul.